The Supreme Court of Ohio ruled a police officer may extend a lawfully initiated traffic stop to investigate the status of a driver's license, even after the reason for initiating the stop is dispelled. A Supreme Court majority upheld the conviction of Quentin Phipps. Officers stopped Phipps in December 2018 after observing him driving with only one functioning headlight. After initiating the stop and obtaining Phipps' information, the officers discovered that they might have been mistaken about the headlight. The traffic stop nevertheless continued, and the officers discovered that Phipps was driving without a valid license and that he had an outstanding warrant. Acting on this information, the officers arrested Phipps. A subsequent search of his car revealed crack cocaine and a digital scale. Phipps was charged with 2 drug-related crimes. He asked the Cuyahoga County Common Pleas Court to suppress the evidence, arguing that once police learned his headlights were working, they had no right to prolong the stop to inquire about his license. The court rejected the argument and denied Phipps' motion to suppress the evidence. Phipps pleaded no contest to the charges and was sentenced to 5 years in prison. He appealed, and the 8th District Court of Appeals vacated his convictions, finding the search was illegal. The Supreme Court decision reversed the 8th District's ruling. Writing for the court majority, Justice Joseph T. Dieters explained that the majority based its decision on 2 grounds. Under U.S. Supreme Court precedent, an officer can investigate the status of a driver's license even if the reasonable suspicion that was the reason for the stop is dispelled. Second, if a driver fails to provide a license, an officer has a new reasonable suspicion of a crime to justify an investigation.
During those inquiries into Mr. Phipps' license status, it was revealed additional facts that Mr. Phipps was not driving with a license because he didn't have his physical card, and all he was able to produce is his name and social security number. At that point, that provided Officer Rose in this case with reasonable and articulable facts that Mr. Phipps was not driving with a valid license.
When an officer discovers facts during a traffic stop that give rise to a reasonable suspicion of criminal activity, the officer may extend the traffic stop to investigate. This is so, even if the suspected criminal activity is beyond that which prompted the initial stop, Justice Dieters wrote. In a concurring opinion, Chief Justice Sharon L. Kennedy stated that Phipps' constitutional rights were not violated because the investigating officer had an unbroken chain of reasonable suspicion throughout the traffic stop.
Fog light is not a headlight, and anybody who's seen the front end of a car knows the difference between a fog light and a headlight.
Sure, Your Honor, but we're talking about the initiation of the stop.
Right, so the initiation was allegedly there was a headlight out.
Police are allowed to make reasonable mistakes, Your Honor, and the trial court here...
How do you mistake a headlight for a fog light, or a fog light for a headlight?
Because we're perceiving things in the dark.
The court noted that Phipps raised additional arguments in his appeal to the 8th District contesting his conviction. The court remanded the case to the appeals court for further proceedings to address Phipps' unresolved assignments of error. You can follow other cases before the court by visiting our website at supremecourt.ohio.gov and signing up for case activity notifications.